All jurors are present in the county court, Judge.
All right, you all can be seated, please. Welcome back, jurors. I want to apologize, it's sort of too strong a term, but I share my regrets that we stretched as far as we did. It's not my normal practice to wait until you're literally famished before we break for lunch. I was looking for a good break point, and it didn't arrive, and we had the funky late morning break, and so I'll run it differently tomorrow. But don't assume that the new normal is we eat lunch at 4. It's not going to be that way. We will have an afternoon break, not promising when, and we're going to end around 5 for the jury's vote. And one other thing, the letters that you all asked for, we're going to make available on Friday because they actually say you've been here all week, and we wouldn't want one of you taking one today and not coming back and then saying, look, I was stuck in court the rest of the week. But they're actually ready. We'll get them to you on Friday. They explain where the heck you've been the last however many weeks it's been, that you get a week off, but that you actually do need to come back. You didn't win the lottery, we're back here, and we'll pick up then. I haven't forgotten those letters. They just mean more coming on Friday. Ms. Clark-Palmer, you had asked Mr. Driscoll about clay management being in the will. You're free to continue with that or go in a different direction.
Thank you, Your Honor. Mr. Driscoll, did you have a chance to review the will and see if clay management is referenced in the will?
I did, and I did not see it referenced.
Thank you. There are times where people may have the ability to take money out of a bank account, even if that's not their bank account. And if I could give you an example, like say a bookkeeper at a law firm or an accounting firm, that individual has the ability to deposit money, withdraw money from the business's account, but that's not the bookkeeper's personal money, correct?
I suppose.
The bookkeeper wouldn't put, well, the bookkeeper is, in my example, right, is acting at the direction usually of somebody else, telling the bookkeeper, you know, what are the expenses for the firm, you know, what are the monies to be deposited, right?
Okay.
And the bookkeeper generally is not free to go spend that money on clothes or a vacation or a personal expense without permission of the law firm or the accounting firm. Fair?
Fair.
All right. The bookkeeper is not permitted to list the law firm's operating account as an asset on her net worth statement, right?
I wouldn't think so.
Because it's not her money, right?
Okay.
Am I right or wrong?
I mean, there's a lot of hypotheticals, but I mean, what you're saying seems reasonable.
You work in an accounting firm, right?
Yes.
Okay. Do you all have an office manager or a bookkeeper?
No, not. I mean, probably somewhere, but not in our office.
Okay.
You guys can all keep your own books, you're
It's not unusual for have you ever done the books or done any work looking at the finances for a business like a law firm or some other business like that?
I kept the books for some real estate transactions early in my career. That's what you mean.
Okay. You said you kept the books for some real estate transactions?
I worked for a real estate development firm, and so I was responsible for the accounting records for certain real estate portfolios.
Okay. My point is that there are times where somebody may have a signatory authority on an account that isn't necessarily their own personal account, right?
Sure.
Happens in business sometimes, right?
Yes.
Okay. And so there are times where somebody may have the ability to withdraw money from a bank account, but not necessarily reflect that bank account on their net worth statement, right?
Sure.
Okay. In the bookkeeper example, the bookkeeper has duties and responsibilities to the law firm that he or she works for with regards to that bank account, correct?
In your hypothetical, yes.
Yeah. So merely having the ability to withdraw funds from a bank account doesn't mean you can list it as an asset on your net worth statement.
Correct.
Okay. And you told us before about getting some documents from the lawyers, and in particular, I'm talking about documents that came from Kirk Watkins.
Yes.
All right. And who did you understand Kirk Watkins to be?
The lawyer for the McIvers.
For Mr. and Mrs. McIver?
That's my understanding, yes.
And your understanding is based on something that was told to you by the DA's office?
Yes.
Okay. But you understand that Kirk Watkins is not somebody who's sitting over here at the defense table today, right?
Not that I'm aware of, no, I wouldn't know.
Okay. Is it your understanding that he represents the estate of Diane McIver, or you're just not clear on it?
I'm not sure I was ever told that there was a distinction.
Okay. You were just told he represents Mr. and Mrs.
Yeah, I saw the documents, I asked who he was, and they said he was a lawyer that was working with the McIvers.
Okay. And they said, the DA's office told you that?
Yes, I don't recall who at the DA's office, but one of the lawyers working for the DA informed me that that's who it was.
Okay, all right. And that's all they told you? Didn't explain any further what his capacity was?
I don't think I asked any follow-up questions.
Okay. All right, so let me show you states 147-38, which we looked at before. It's this email back and forth where Mr. McIver in June of 2016 says, I'm trying to reduce my monthly expenses.
Yes.
Debt is my biggest obstacle right now.
Yes.
And then there's Ms. McIver responds, make sure you read Javier's job description. Right.
Yes.
And you told us that your understanding is Javier is somebody who works at the ranch, correct?
That's my understanding, yes.
And he's paid to work at the ranch, correct? Do you know?
I don't know.
Okay, you don't know. All you know about Javier is he works at the ranch.
Yes, I don't know how he's compensated.
Okay. Do you know if he's compensated at all?
I know that there are some transactions that where that's what the description says, but I mean I've never seen I've never seen a check that is written from one account to Javier. I don't believe.
Okay. All right, but you've seen some other documents that make reference to compensating Javier.
Yes.
Okay.
Yes.
So she says, read Javier's job description. That is your next life chapter. Save you lots of moolah, right? That's what it says?
Yes.
Okay. And then there's this sort of light-hearted exchange where Mr. McIver says, oh, well, back to jig blowing, right?
Yes.
Okay. That's a fair characterization, a light-hearted exchange, right? Right? Presumably he's...
It's really cause for speculating. The document speaks for itself.
Okay. We can move on. It's
Okay.
fine. But the talk and the subject of this email is talking about, the content of the email is talking about reducing monthly expenses for Mr. McIver, right?
He says that's his concern.
Right. And this is in June of 2016, right?
Yes.
And we've talked about at this point in time, his income from the law firm is going down, correct?
Yes.
And at this point in time, he knows he's not going to be working at the law firm in a short amount of time, right?
Yes.
Okay. And in going back and looking at your analysis of his cash flow, he needs, the cash flow is a problem for Mr. McIver because his expenses are greater than the cash coming in, correct?
Yes.
Okay. And talking about did you say during your direct testimony that Mr. McIver was cash poor?
That's the term I used, yes.
Okay. Meaning that he didn't have a lot of cash on hand. right?
Right.
Okay. Not necessarily talking about what assets he had available to him, but talking about the cash that he had, right?
Yeah, I think that term doesn't have anything to do with assets. It has to do with, kind of what cash you got coming in the door.
Okay, well, that's going to be my next question is, you weren't looking at, well, does he have assets that he could liquidate? You're just talking about what liquid assets, what cash did he have on hand at that time to meet his expenses, right?
Well, in that first opinion, in those slides, I focus on the cash flow issue. I deal with the assets in the second opinion.
Right. Okay, so when we're just talking about the cash, he had assets available to him that he could have liquidated, correct?
Yes,
But that wasn't your focus in rendering that part of the opinion?
correct.
Okay. The ranch is not a liquid asset, correct? It's not cash.
It's not cash.
Okay. So, getting the ranch as a sole owner doesn't immediately help Mr. McIver with his cash flow problems, correct?
Not unless he were to sell it.
Okay. He could sell it, right?
Yes.
Okay. He could take a mortgage out, try to refinance it and take a mortgage out on it if he had equity in it, correct?
In theory, I don't know what his, I don't know what his relationship with his bankers or, I don't know. I'm not the right person to ask that, but theoretically, yes.
But taking out a mortgage on the ranch may give you some money, but also adds to your expenses as well, correct?
Correct.
Okay. One of the sources of cash he was relying on in September 2016 was his wife, right?
Yes.
His cash flow problems were greater after she died because he no longer had the cash coming from Diane, correct?
Well, after she died, he got cash from a different place.
But he's not getting the transfers from her, he's not getting transfers from her into his bank accounts, correct?
Technically, she cannot obviously transfer money to him anymore. Yes,
Right.
That's true.
All right, and when you say he's getting cash from other places, you're talking about life insurance,
Yes.
401k,
Yes.
okay, and the cash she has on hand.
Yes.
You are assuming that he gets the cash she has on hand because he is the executor of her estate?
He has access to it. Yes.
As executor of her estate? Okay. When you say he has access to it, and I know we talked about this before, and I'm not going to go over everything you told us previously, but I want to make sure I really understand what you're telling us. Is it your opinion, or is it an assumption that because he is executor of her estate, he can use whatever cash is in her estate to pay for his own expenses and liabilities?
I don't know what he used. I don't know what he's legally allowed to use. I just know that as of that day, he would have had control of that money.
And when you say control of that money, you mean he is able to take money out of the bank account, right?
Close the account, move the money, and control the funds that were in the account. Yes.
Okay. But you don't know what his duties and responsibilities are as executor of her estate?
No, I don't.
That's a question we need to put to a different person.
Yes.
And if there are restrictions, or if there are duties and responsibilities he has as executor of her estate that keep him from being able to use those funds for his own personal liabilities and expenses, they are not an asset of his. Is that fair?
If he is unable to control them, yes, then they're not. They wouldn't be considered assets.
All right. If he is unable to control the cash that is in her estate, his cash flow problems were not as bad when Diane was alive, correct? If he does not have access to the cash that is in her estate after she dies, if he doesn't have access to that cash, his cash flow problems were better when she was alive because she's giving him money every month.
I don't know that she's giving him money every month.
She's giving him money, period.
She's loaning him money.
Well, there's one loan, there's the $350,000 loan, correct?
Yes.
What other loans did Diane give to Mr.
There were
McIver?
checks. I mean, oftentimes when she would give him a check, it would say loan and then a line.
Okay, all right. So there were some checks that said loan in the memo line item, but there were some checks that didn't say loan at all, correct?
Yes.
Okay, so, but you didn't see anywhere any note or anything written down where it said that Diane McIver owes Tex McIver money. You're just going off of what was in the memo on the check.
Or Diane, you said Diane owes
Yes,
tax money?
yes. May I ask you a different question?
Sure.
Okay.
Please.
My question is, if you assume he does not have access to the cash in her estate, my initial question was, his cash flow problems are not as bad when she is alive because she's giving him money.
I'm not sure I agree with the premise of the question.
Which part?
Well, you're saying he has no ability to get to the cash. I mean, the 401k money was transferred into his name, so he would have had access to that.
Okay. And I'm saying, set that aside. Set aside the life assurance. Set
Oh, I didn't
aside.
realize we were setting aside all of this stuff.
Okay, I apologize for not being clear. Set that aside.
You're just talking about the 275.
Let me again start over and see if I can do this in smaller pieces. You saw where for years, back to 2013, there was money going from Mrs. McIver to Mr. McIver.
Yes.
Okay, every month or just a lot?
Here and there, yes.
Okay, here and there. So over the course of the whole year, there was money going from Mrs. McIver to Mr. McIver.
Yes.
She was giving him more money than he was giving back to her,
Yes.
typically. His sources of cash included those monies coming from Mrs. McIver.
Yes.
Okay. You showed us on one of your slides where, I think it was in September of 2016, without the money she gave him that month, he would have been negative $5,000.
Yes.
Okay? So my question is, set aside the life insurance, set aside the 401k, assume he can't control the cash that's in her estate. His cash flow problems are not as bad when his wife is alive and she's giving him money.
So the question is, if I eliminate the entire $1.2 million and assume he can't acquire a dime of that, is his cash flow worse? I mean, if his problem is worse, yes.
His problem is not as bad when his wife is alive.
Yes.
Okay.
Assuming all of those assumptions, yes.
You told us that the life insurance, there was a claim for it, but it had not actually been paid, correct?
Yes.
Okay. In other words, that $600,000 never made it into a bank account of Mr. McIver's.
To my knowledge, I have not seen a bank account where it's gone into, so I'm assuming that that's the same point as period.
Okay. We talked about the 401k being $288,000-ish, right? You have to say yes or no.
Oh, yes, sorry.
And then you told us you just don't know what the duties and responsibilities of an executor are,
I'm
right?
just going to object.
When you start your question, we've already talked about why are we going back to the 401k maybe for a third time now? You're examining, not adding in direct. Is it a different context?
I'm finishing my cross, I'm emphasizing a point. On direct, Mr. Rucker would...
My question is what you're doing, not what Mr. Rucker
I'm
did.
emphasizing a point and finishing my cross.
Okay, it's about the executor. He's already said that's not his wheelhouse.
Okay, she's emphasizing a point.
Right?
I have to repeat the question. I forgot that now.
You don't know what the duties and responsibilities of an executor of an estate are, correct?
I do not.
Thank you, Judge.
Redirect.
Okay. Let me show you states 441. It's already been entered into evidence. Can you just tell the jury real quick, what is that document?
The last will and testament of Diane S. McIver.
Okay. And could you flip over to page to the first typewritten page?
Yes, sir.
Okay. And can you tell the jury, under item 3, Roman numeral 3, subsection A, do you see where it says, I give, devise, and bequeath as follows all of my interests in the farm, and it gives the address, right?
Yes.
All the furniture, art, furnishings, livestock, equipment, and other personalty, right?
Yes.
And then it says, I give, devise, and bequeath to who?
Claude L. McIver III.
The defendant is a beneficiary in this will, correct?
Yes.
Subsection B, do you see where it says all the furniture, art, and furnishing at the condominiums, and she lists the numbers at Kingsborough Road, Atlanta, I give, devise, and bequeath to who?
Claude L. McIver III.
Okay. So in addition to being the executor, he's also a beneficiary under the will.
Yes.
And you were asked some questions about whether or not play management actually appears in the will. Could you flip over to page 3?
Yes.
You see item Roman numeral 6?
Yes.
And can you tell the jurors, subsection A, does it say all the rest, residue, and remainder of my property of every kind and description and wherever located, I give, devise, and bequeath to Kenneth Rickard,
Yes.
named and hereafter referred to as trustee.
Yes.
Subsection B, the trustee shall pay the net income from the property currently to or for, what does the rest of that say?
To or for the benefit of my husband, Claude L. McIver III.
Let me ask you real quick. Based on the documents you received, did you have an understanding about how this company that you talked to Ms. Clark Palmer about on Cross, DRS, how it was structured? Do you know who the owners were?
Yeah, I believe it was a 50-50 partnership between her and another individual that I'm forgetting their name right now.
Okay.
Richard Harrell, sorry.
You remember Richard Harrell?
Yes.
Okay. So Diane McIver had 50%.
Yes.
Richard Harrell
Yes.
had 50%, right? Now, upon Ms. McIver's death, do you know who her 50% interest in DRS went to? Do you know?
No, I don't know.
Okay. Upon her death, can you tell the jurors, if a debt of $975,000 was owed by DRS to another company, I think what you told Ms. Clark Palmer is that's a liability.
Yes.
Now, she also asked you about a $1 million life insurance policy on the life of Diane McIver that, based on your analysis, was it used to cover this $975,000 debt?
Yes.
Okay. And can you tell the jury, if Ms. McIver is only a 50% owner in DRS and the liability is $975,000, what would be her percentage of that liability?
Well, unless the operating agreements for the company said something different, it would generally be split between the owners.
Split in half?
Yes.
I don't do math, but $975,000 divided by 2 is how much? 487,500?
Sounds right.
Bad for a non-master.
Would a $1 million life insurance policy cover $487,500 worth of liability?
Yes.
Go to another area. This is Arcilla Mining and Land. This is the letter, State Exhibit 148. You asked a lot of questions by Ms. Clark Palmer about valuation of Mr. McIver's interest in Arcilla Mining and Land. This letter came from Ted Smith, President and CEO, correct?
Yes.
And after he gives you a range of 1.5 million to 2.5 million, the way he concludes the letter is by saying this evaluation is to be considered strictly confidential and is, what's that word right there?
Not.
I can't hear you. Not to be used as an appraisal, submitted as, what's that word?
Evidence.
Evidence or as an official document, right?
Yes.
Who tendered that? Someone's in trouble.
Let me ask you about this question. Ms. Clark Palmer asked you, she asked you some questions about a bookkeeper. Remember she gave you a hypothetical about
Yes.
a bookkeeper, and if a bookkeeper, could they use the money and put it to their own personal account? You remember those questions?
Yes.
I saw you over there struggling. So let me just ask you this, that same hypothetical. Could a bookkeeper for, I think, a law firm, accounting firm, or whatever, put money into her account legally from
Yes.
somewhere else?
Yes.
Okay. She could also do it illegally.
Sure.
Right. Oh, Ms. Palmer asked you some questions about all the assets that she says that her client had at the time of Mr. McIver's death. Remember she talked about the 1.2 million and some other assets that he had
Yes.
that were not liquid. Remember she used that word with you?
Yes.
And by liquid, we're talking about like cash on hand, right?
Yes.
And, but let me ask you this. Did you tell her that the ranch could be sold?
Sure.
Even before Miss McIver died, his interest in the ranch could have been sold.
Sure.
And he could have sold that interest in the ranch and used that money to pay his wife back that $350,000, couldn't he?
Theoretically, if he could have gotten enough to pay the debts off, sure.
Do you have your page 16 and 17?
Of the
Your
PowerPoint?
presentation?
Yes.
Okay. Page 16. Okay. If we take out the amount of money that Ms. McIver gave to Mr. McIver before her death, how much cash does Mr. McIver have in his checking account on the day of her death?
Negative $5,301.
Flip over to page 17. How much cash, liquid cash, assets is at Mr. McIver's access the day after she died?
$1,167,405.
And I think what you told Ms. Clark Palmer is that the 401k, the $288,000, that went straight into his bank account.
It was transferred into his another retirement account that he controlled in early 2017. So it took a little while,
Okay.
but yes.
Okay. So when Ms. Palmer asked you, she gave you 3 scenarios on cross-examination in order to solve Mr. McIver's cash flow problem. She said to you, the defendant could just make more money. Remember that?
Yes.
Have you talked to Mr. Wilcox, who is associated with a legal head hunting firm as part of your analysis? Did you ever talk to him?
No.
Okay. So you have no information about the defendant's ability to make more money as a lawyer?
No, I do not.
She also said he could reduce his expenses. Remember that?
Yes.
Did you see any indication in the 3-year history that you reviewed for all of his bank accounts and checks flowing in and out of his account, any sign of a reduction in his monthly expenses?
The trend was for lower expenses as a whole, but the expenses that were causing the problems, which were the ranch expenses, were not going down.
Right. They stayed pretty consistent.
Yes.
And she said the third thing is that to solve this problem, he could just rely on his wife to give him money. Remember that?
Yes.
But the money from his wife didn't stop after she died, did it?
No.
Do you ever see in the history of all the documents you reviewed that Ms. McIver ever wrote her husband a check for $1.167405 million?
No.
Thank you very much. I believe that's all my research, Your Honor.
Jurors, if you have collected any questions, send them please to your left and down to 61 card keeper for today. Well, please. Thank you, sir. So, Mr. Driscoll, some of these questions are going to be prefaced with the phrase, do you know? If you don't, just, I don't know, don't speculate or anything like that. Did you ever receive any information about a $750,000 loan that Ms. McIver made to Mr. McIver earlier times than some of the years you were working?
I've seen documents related to it, yes.
Did that $750,000 loan factor in any way the calculations you were making?
No. While there were no documents that showed that that debt was cleared, I think the assumption was that it was at some point through refinancings or something else, is that because it was replaced later on with a different debt. Is that clear?
We'll see if the attorneys want to follow up. You don't get to ask me questions.
I've been a professor too long.
It's a good question. The $288,000 and change of 401k money from Ms. McIver that went to Mr. McIver, do you know if that was a pre-tax or post-tax amount?
It was a rollover, so it wasn't taxed.
It was a no tax amount?
No tax event.
Okay, all right. And the life insurance policy that was discussed with you that was taken out in connection with the debt that DRS owed, was that life insurance policy included in any of the work you did on Ms. McIver's net worth calculations?
No.
You had a figure in one of your calculations, $100,000 for furniture. Do you know if that $100,000 figure
was for furniture for just the condo, just the ranch, or both? Or am I asking you too vague a question?
I don't know.
But it was a single line item?
Yes.
Okay. And then there was a $1.3 million figure for the ranch. Do you know if that was what are the origins of that figure? Where did 1.3 million come from?
So the listing of the total real estate assets was $2 million. And it wasn't broken up between, this was what was on Mr. McIver's personal statement. It said $2 million for real estate. I don't know how it was broken out. I don't know what his intent was to break it out between the Buckhead condo and the ranch. But I did have an appraisal for the Buckhead condo of $650,000. So I took the $2 million, I subtracted the $650,000, and I allocated everything else to the ranch. And so when I split it 50-50 between Mr. McIver and Mrs. McIver, it's based on that number. That's the best evidence I had.
Speaking of the condo, do you know if the condo was ever sold?
I don't know.
Okay. There was an email that I think both sides asked you about from June of 2016. Remembering that email?
Yes.
The subject line referred to a Wells Fargo 15-year fixed something. Do you know anything about what that loan was for, or the terms of it, or anything like that?
The early part of that email string dealt with, and I don't remember the parties, but it was Mr. McIver talking to some bankers about a refinance. And then he turned around and forwarded that email to his wife with the comments that we talked about. That's the origins of the original email.
When you say the refinance, do you know what that loan was for? And if you don't, you don't.
I don't off the top of my head. I could go back and look at the document, but I don't remember. I believe it was for well, I won't speculate because I haven't looked at the document in a little while.
Okay, if the attorneys want to follow up, they can. Last question, and if you need to consult your report, that's fine. Could you share with the jurors, again, what Mr. McIver's net worth was as of September 2016?
My calculation was $1.7 million, assuming that those categories that I talked about were valid. I just don't have any ability to validate them.
Mr. Rucker, any follow-up based on those questions?
Yes, Judge. Let me show you State's Exhibit 147, 38. Let me just hand it to you first and give you an opportunity to read over it yourself.
Okay.
Okay. Can you tell the jury what is that exhibit?
This is the beginning of the email string that we just talked about.
Okay. And so can you tell the jurors how does the email string begin?
It's an email from Anthony Leatherwood at Wells Fargo to Tex McIver dated June 15th, 2016 at 8:39 a.m. Subject line Wells Fargo / 15-year fixed.
Okay. And I don't know, Counsel, do you have an objection to the actual reading of the actual email or? Okay. Could you just read the email, how it reads?
Sure. Good morning. Sorry for the delay. I emailed you yesterday, but just noticed that I left the quote-unquote S off labor lawyers in my email, so it never went through. Here's the info I promised. Hey Tex, here's the best offer we could do for a 15-year fixed refinance. Your existing rate is 3.375%, and you are slightly more than 4 years into the existing loan. We can get you 2.75% with 0 discount points for a new 15-year fixed today. Closing cost would run at $4,200 for this scenario. Some clients prefer a no closing cost option where we lender pay the $4,200 of closing cost. The no closing cost rate would be 3.125%. Assuming you pay the closing cost out of pocket, monthly payment differences at $58 a month between the two rates. If you roll the closing costs into the new loan amount, the payment difference is $31 a month difference. And then there's a indention, it says the 2.75% option with you paying closing costs out of pocket decreases your monthly payment by $750 per month. Let me know if you would like to discuss further or begin the application process. I can normally gather enough info over the phone in about 15 minutes to put together the new application. Once I decision through our system, I can let you know what we would need from an income/asset documentation perspective to submit through underwriting for approval. Talk to you soon. Anthony Ray Leatherwood, home mortgage consultant.
Okay. And in some layman's terms, for folks who might not be familiar with what you just read, kind of how would you break that down and explain to the jurors, like if I were like 8 years old or something?
Mr. McIver was attempting to lower his monthly mortgage costs by getting a better rate.
Okay. And the difference in the two options he had was basically about what?
About $31 a month.
Okay. Could you read for the jurors, what is the next email in the chain?
The next email is dated June 15th, 2:51, so this is later that same day. Mr. McIver forwards this email to Richard Harrell and Diane McIver, and he writes, "What do you think of this proposal? My current mortgage is with Wells, so it could be an easy transaction. I do intend to negotiate down the $4,200 with my friend, who is the Southeast Regional President of Wells."
Okay. Could you read for the jurors, what is the response to that?
It's not going to be as long as the first one?
No.
No, it's short.
Progressively short.
But on June 15th at 2:56 p.m., so 5 minutes later, Mrs. McIver writes back to Mr. McIver and states, "I would worry more about paying off your second mortgage than refinancing. But if you did refinance, the 2.75 with you paying the closing cost is the best option for you."
Okay. And by the way, did you know what kind of work Ms. McIver did?
I know that she was the president of a company, but no, not what she did day to day.
Okay. What is the response to Mrs. McIver's email about what is the best option for her husband?
That's when he writes back and says, "I'm seriously trying to reduce my monthly expenses. Debt is my biggest obstacle right now. Planning on hitting the lotto sometime this week."
And then what does she say back?
Well, that part we've covered now a bunch of times.
Okay. All right.
And it's in evidence.
And it's in evidence. And with the court's indulgence, I would like to cross, well, the entire line was not read for the jury. It's just one sentence. If the court would indulge me on that.
Okay.
Okay, I appreciate it. And this is the line, if you could, for the jurors read, starting right here with you. What does Ms. McIver say back to Mr. McIver?
Says, "You will be standing there with your hand out when I get in the door every Friday."
Thank you.
Ms. Clark-Palmer, any follow-up based on the questions I've had through the jurors or just?
Mr. Driscoll, you told us the 401k was a rollover
Yes.
when it went to Mr. McIver. Okay, so what is a rollover?
A rollover is like when you change jobs. You can move your 401k from one entity that holds the money to another entity, and it's not a taxable event to you. If you were to take money out of your 401k at a normal period, not only would you pay taxes, but you'd pay penalties if you were not at a certain age. And we're not going to
Right.
count the
Yeah.
That's what a rollover is.
It did not go into Mr. McIver's checking account
No,
or a savings account?
no.
Okay. And you calculated Mr. McIver's net worth as of September 26, 2017. You told us that was the 1.7 number, correct?
Yes.
Which this number does not assume that there should be an additional 1.5 or $2.5 million credited for Arcilla.
I'll
Correct.
qualify that like I did before, which is assuming that there's none of those assets relate to Arcilla, and assuming that his minority interest value of Arcilla is between 1.5 to 2.5 million dollars. Assuming those things, yes. Right.
With those assumptions, this number could go up.
Yes.
Mr. Driscoll, we appreciate your time and your binders and all the things you shared with us. Thank you very much. Thank you. Next. Goodbye.
Good afternoon, Judge.
Good afternoon.
Stay with me.
Mid-drink there.
Dave would call Mr. Baines.
Ready, Judge?
Yes, please.
Raise your right hand. Do you swear and affirm that the testimony you should give the court today will be the truth, the whole truth, and nothing but the truth, so help you God? Yes, sir. Yes, sir. If you will, please have a seat. During your testimony, get as close to the mic as you can. For the purposes of the court's record, please state and spell your name.
Victor Bain, Victorbayn.
Say, good afternoon, Mr. Baines. Could you turn and introduce yourself to the jury and tell them what you do for a living?
I run a retail store. My name's Victor Bain. I run a retail store in Millersville, Bain's Army Store. We sell sporting goods, hunting apparel, guns, ammo, archery, related items.
So we're going to mic you. It sounds like the court reporter's having some trouble. So until we get that done, just speak real loud like you're outside.
Okay.
And where's your store located?
It's in downtown Millersville, on South Wayne Street, in the heart of downtown.
And how long have you owned that store?
My father had it before I did. I've been operating since 1979.
Okay, so it's a family business.
Yes, sir.
And what kind of items does your store sell?
We sell hunting apparel, boots, clothing, all kind of outdoor gear, guns, ammo, archery.
Okay. And what kind of guns does your store sell?
Long guns and handguns.
Give us an example of a long gun.
Long guns like a shotgun, semi-automatic shotgun, pump shotgun, single barrel shotgun, deer rifle, bolt-action deer rifle, semi-automatic gun.
Okay. You know your guns. Now, speaking of that, would you consider yourself to be very knowledgeable, I guess, with guns?
I suppose so, yes.
Okay. And you said ammo. Does your store sell all kinds of ammo?
Pretty much all kinds of ammo, yes.
And how long, I guess, have you been shooting firearms?
Pretty much since I was 11, 12 years old.
Okay. And since then and to now, have you received training, certifications on gun safety?
Yes, sir.
Okay. And what kind of trainings or certifications have you received?
I went through an NRA certified instructor course, and I've been through a couple of different hunter safety courses.
Okay. And does your store offer any of those courses?
No, sir.
Okay. Do you know the defendant, Mr. McIver?
Yes, sir.
And how do you know Mr. McIver?
He was a customer of ours.
Okay. And how long was he a customer?
I would say a dozen or so years.
Okay. 12 years or so?
Yes, sir.
Okay. And in those 12 years, did he purchase firearms from you?
Yes, sir.
Okay. Do you remember about how many?
A dozen, 15, 18, somewhere like that. I'm not exactly sure.
Okay. And how often would he come in to purchase weapons each year?
Well, he would come in pretty often, but he didn't purchase a gun every time he came in. He'd buy a couple of guns a year probably.
Okay. And what types of guns did he purchase from your store?
Hunting guns, mostly, shotguns and rifles. Purchased a few handguns.
Purchased a few handguns. Do you remember the kind of handguns that he purchased from your store?
Not really. I gave y'all a list last year of some of them that he purchased, but I don't have it in front of me.
Did you ever have an opportunity to shoot with the defendant?
No, sir.
Did you ever see him shoot?
No, sir.
Did he ever talk about, I guess, his knowledge or proficiency in the use of weapons with you?
Well, I knew he hunted some, and he was in the military, but no, I didn't. I never went hunting with him or saw him shoot.
And did you ever have an opportunity to meet Miss Diane McIver?
Yes, I met her a few times.
Okay. Did she, in the times that you met her and she came into your store, ever purchase any firearms?
I remember her purchasing one handgun.
Okay. And did you ever have an opportunity to meet Austin Swall?
Yes.
Okay. And how was that?
He came to the store with Tex.
Okay. Now, would you consider the majority of your, I guess, customer base to be gun enthusiasts?
Yes, sir.
Did Mr. McIver ever purchase any ammunition from you as well?
Did who?
Mr. McIver, the defendant?
Yes, he did.
Okay. And would he purchase that often, or would he purchase that only when he bought firearms from your store?
He would probably purchase ammo along the way, not necessarily every time he bought it.
I'm sorry, repeat your question. The answer is, you would probably,
He would probably purchase ammo along the way, not every time he came in there, but, if you were a hunter or a shooter, you couldn't use ammo, had to replenish it.
Okay. I don't think I have any further questions. Thank you, sir.
Thank you.
Good afternoon.
Good afternoon.
My name is Amanda Clark Palmer. I think you and I maybe spoke on the phone one time before.
Yes, ma'am.
I missed, the question was asked on direct, I missed your answer. Did you tell us about how often Mr. McIver would come into your store?
Every few weeks, usually it was on a Saturday, when he would come to town to go to the feed store.
Okay. And at your store, it sounds like on some occasions he would purchase different guns from you.
Yes, ma'am.
But is it fair to say on the majority of the occasions he's purchasing other things, ammunition? What are the other things you sell?
Correct. Clothing, hunting clothing, boots.
All right. And you have other customers besides Mr. McIver, correct?
Correct.
All right. And you have you sell guns to people other than Mr. McIver, correct?
Yes.
Okay. And you said that Mr. McIver has purchased over the years, your best guess, maybe 12 or 18
Yes.
guns from you? And you have customers who have purchased more guns than that from you, correct?
Correct.
Do you have customers who come in and purchase a gun every week?
Just about.
Okay. Thank you.
Thank you.
Any redirect? No. Any questions from the jurors? Mr. Bain, we appreciate you coming all the way from Millersville.
Thank you.
You leave the microphone behind, you are free to go. Next witness.
And Your Honor, before we call the next witness, I would like to have the court have to deal with the stipulation between the parties that we discussed.
Okay.
Which one?
Dick.
Okay, can someone move the microphone near the other microphone? And we're not going to gear everyone up every time. We'll see how they do. We got through a bunch of the trial without that, but if we need to clip it on someone, we will. Ladies and gentlemen, you are about to hear an excerpt from an interview that Mr. McIver participated in on April 28th of last year. A television reporter showed up where Mr. McIver was without advance notice, asked to speak with him, and Mr. McIver agreed to speak with him. He was not under oath. This wasn't a law enforcement interview. It's a conversation that Mr. McIver had with the reporter, for reasons I'm sure you can understand, these have been pretty heavily edited because what the reporter says isn't what we're here about. And so don't be surprised if it is condensed and a little choppy. You'll be hearing the relevant portions of that conversation from April 28th of last year. Does this have an exhibit number that I can put on my unrevised exhibit list?
It does. It's 485.
Okay.
Your Honor, may we publish?
Sure. Hold on, take it down. You want to take that down too? It's neither. It's not. Would it make more sense to go to a different witness so you guys can work through this? More time is not an issue. If you need more time to talk about it, I understood that.
I thought so too.
Okay. Okay, let's call another witness, please.
Sure.
You guys stay tuned for 485.
We're going back to the...
Sure, please do. Next witness.
Yes. Judge, the state would like to recall Mr. Kenneth Rickard for a very, very limited purpose.
Okay. You all remember Mr. Rickard?
See me again.
Hello, Mr. Rickard. Welcome back.
Yes, love to be here.
We've got to swear you in because this is a separate appearance, so we'll have the deputy come here and swear you in. And you'll see that our procedures have changed once you're sworn in.
Do you swear from testimony you get in court, the truth, the whole truth, nothing but the truth, so help you God? I do. Okay.
I've been asked by the court reporter to have all the witnesses wear the mic. So you're going to wear a portable mic as well.
Kenneth Rickard.
You're the same Kenneth Rickard?
I am yes, I am.
Okay.
Hey, good afternoon.
Good afternoon.
I appreciate you rushing down here. I had somebody call you a few minutes ago. Hi. Yes.
I'm glad I was in the office.
Me too. I have a really short area I want to talk to you about, and it has to do with DRS. And could you just tell the jurors, what is your understanding about the way DRS was structured?
It was a corporation that was owned 50% by Diane, 50% by Richard Harrell.
Okay. And the only thing I want to ask you about is the $975,000 claim against DRS. Can you explain for the jurors, was that debt satisfied?
It was a claim that was, yes, it was satisfied.
Okay. And can you tell the jurors, was there a $1 million, the phrase is a key man life insurance policy?
I wouldn't necessarily phrase it as a key man insurance policy, but there was a $1 million policy that was there.
Okay. And can you tell the jurors, was that policy used to satisfy Diane McIver's portion of the debt that DRS owed?
$500,000 of that $1 million policy was used to satisfy the claim against the estate that rose from Diane McIver.
Okay. And so as of this date, are there any debts owed by Diane McIver's estate with respect to the debt that was filed against DRS?
No, everything's been paid in full.
Thank you.
Hello again.
Well,
I'm going to stand up here if that's okay.
sure.
Okay. There was a claim made against Mrs. McIver's estate for $975,000, correct?
Correct.
the money was owed from Diane to DRS, right?
Correct.
And then the money that she owed to DRS got assigned to U.S. Enterprises, right?
Yes,
So U.S. Enterprises ultimately was the one that said, Diane McIver's estate, you owe us $975,000,
that's correct.
okay? The $1 million policy, half of that gets credited to the $975,000, correct?
Half of that went to the estate, would have gone to the estate, half of that would have gone to Mr. Harrell.
Okay, and the half that goes to the estate ultimately goes to U.S. Enterprises.
Yes,
So now, Diane's estate still owes U.S. Enterprises $475,000.
approximately, that's
Okay.
correct.
That gets satisfied. One of the ways it gets satisfied is the estate gives to U.S. Enterprises some billboards some property that Clay Management owned.
Yes, the estate satisfied, they chose to satisfy it that way, in that manner.
So, all right, just to make sure I've got this right. All right, Diane's estate,
Well, Judge, I'm going to object. This is kind of the objection I've drawn a couple times, that we go back over the testimony you just heard again. So it looks like we're about to repeat exactly what Mr. Ricker just very clearly and plainly explained.
Are we?
I'd like to write it down in visual form, like we've done with other witnesses on the chart, and then I'll be done.
Okay.
Diane's estate owed $975,000, correct? To U.S., ultimately to
U.S. Enterprises filed a claim against the estate for that amount.
Okay. $500,000 to satisfy that, $975,000. $500,000 comes from the life insurance policy, right?
Yes,
The remainder of it is satisfied by I wrote billboard/property that's owned by Clay Management, correct?
yes.
All right, thank you.
Any redirect?
Just the body in my ear. But,
You can confirm.
no, thank you.
Okay.
Any questions for Mr. Ricker, round two?
Okay. If you wouldn't mind collecting the questions from the jurors, please, Deputy.
Thank you.
Okay.
Thank you. Mr. Ricker, of the $975,000 obligation that we've been talking about, was any part of that owed by Mr. Harrell? Of the 975?
No,
Okay. The approximately $500,000 for billboards/property, do you know the origins of the funds that covered the remainder, not covered by the insurance policy, of the debt of the estate?
the only thing I know is that they were owned by Clay Management. I'm not sure where the funds came from, or Diane's funds, but Diane was the sole, she was the sole owner of Clay Management, as we've talked about before.
Do you know who had control of Clay Management after Ms. McIver's death? Because as I understand it, all this happened after she passed.
It did, you're correct in that it took place after she passed. I believe, to my recollection, Clay Management would have been a part of the estate.
Okay. Any follow-up, Mr. Rucker?
I think earlier you said $500,000 of the $1 million got applied to the $975,000 debt. Do I have that right?
Yes.
The other $500,000 from the $1 million insurance policy went where?
To Mr. Harrell?
Okay, went to Mr. Harrell as 50% owner of DRS.
Correct.
Okay.
Ms. Clark, call me.
Mr. Rickert, you said that clay management became part of Diane's estate, right?
To my recollection, yes.
After she died, it became part of her estate, right?
Yes.
And whatever assets and liabilities that clay management had, her executor would have to be responsible for those, correct? The executor of the estate.
Her life, you phrase that again. It was a,
Let me ask a better question. Clay management does not, when Diane dies, clay management does not become Tex McIver's company, correct?
it became part of the estate.
But not Tex McIver as owner and sole operator of the company, correct?
It did not pass directly to Tex McIver under the will.
Right. Goes into her estate, he is the executor of her estate, correct?
Correct.
Thank you, sir.
Thank you.
Don't go too far.
I'll be on call.
Okay. Your boss has been here, so it's good you were available. Was Mr. Bain a replacement for Mr. Farmer?
Yes.
Great. Next witness.
I would like to do the stipulation right now.
We're in good shape. We're in good shape here now.
Good shape.
Okay, this coming from the defense. We're going back to the interview that occurred on April 28th. This is the Diggs matter. Is that correct?
Yes, sir.
Okay, so 485. Do you recall what I said? This is an excerpt from an interview.
About the couple's finances does not match reality.
I am worth 2.5 times what her estate is worth.
That's 485.
As long as everybody heard it.
Okay. So we can all be ready. Let's call the next witness, and then we'll get back.
Sure. It's Investigator Brian Salter.
No questions, Mr. And before we start, my understanding is that this is the witness for which Mr. Harvey has gotten a number of things on the record, reserved those concerns. The state has made certain representations about how this will, one part of Investigator Salter's testimony will flow, and if it goes differently than that, I invite Mr. Harvey to alert me, but I'll be paying attention as well. You don't need it, but it's there. All right, let's swear the witness in.
Raise your right hand, please. Do you swear affirm testimony you get in court today the truth, the whole truth, nothing but truth, so help you God?
I do.
State your name. Please.
Brian Salters, B-R-I-A-N, Salters, S-A-L-T-E-R-S.
And Investigator Salters, we're going to have you wear, if you don't already have it on, that microphone. Get it going so we can assist our court reporter.
Good afternoon.
Good afternoon, sir.
Can you turn and introduce yourself to the jurors by restating your name and tell them how you are currently employed?
My name is Investigator Brian Salters. I'm employed with the Fulton County District Attorney's Office as a criminal investigator.
Okay. And can you tell the jurors how long have you been employed in the Fulton County District Attorney's Office?
I've worked for the Fulton County DA's office for 4 years.
Okay. And as a criminal investigator, what are some of your duties and responsibilities there in the office?
My duties and responsibilities include, but are not limited to, serving subpoenas, interviewing witnesses, providing courtroom security for assistant district attorneys, and being a liaison between the Fulton County District Attorney's Office and all agencies within Fulton County that report to the Atlanta Judicial Circuit in the capacity of being the Fulton County DA's evidence custodian. So evidence related to crimes that need to be transported to court and or transported to GBI for processing, different things like that. I am the agency lead for those matters.
Okay. And can you tell the jury, did you you assist into the investigation and preparation for trial in this case?
I did.
And to be clear, are you what we would call a primary or the lead investigator from the Fulton County DA's office?
I am not.
Okay. I couldn't even get finished before you got that out, Judge. Who is?
Investigator John Griffin, who is the deputy chief investigator, also Cynthia Wakocha, who is the chief investigator.
Okay. Can you tell the jury, did you have an occasion to, as part of the investigation in this case, go to a condominium located in Buckhead?
I did.
And can you just give the address?
So if you're going to look at a document, investigator software, you need to let everyone know so that both sides can be comfortable with what you're looking at.
I'm going to refer to the search warrant. I know the general area, but I do not know the exact location.
Okay. Let me, if it's okay with counsel, can I just, is it okay for me to just get to the address? Okay. Are we talking about the condominium located on Kingsborough?
Yes, we are.
Okay. Condominiums 1501 and 1502?
Yes, sir.
You knew them to be the condos where Diane McIver and Claude McIver lived?
Yes, sir.
Okay. And can you just tell the jury, from your own memory, do you remember the date that you would have gone there?
It was April 14th, 2017.
Okay. And can you tell the jury while you were there, did you locate financial documents?
We did.
And can you tell the jury, did you locate any will for Diane McIver?
I did not.
Now, can you tell the jury, when you were attempting to find a will or financial documents, where did you look?
I searched in the master bedroom. I also searched in the general quarters of the residence. I looked in bathrooms. I looked in the kitchen area. I looked in the family and dining rooms. I pretty much looked over the entire condo, both sides.
Okay. And can you tell the jury while you were there, were these places actually documented with photographs?
They were.
I'm going to show you a series of photos. Your Honor, could you please tell me, do we have a 409 and 410 already admitted? Okay. I think the defense counsel says we have them admitted. I just want to check with the court.
Yes, I also have that down.
Okay. So I would like to show the witness a series of photos, Your Honor. They are marked for identification as State's Exhibit 413, 414, 416, 300, and 301. You need those numbers again?
No, I'm just looking first to make sure. Okay, I see 300, 301 as well. All right.
Okay. And also, Your Honor, I'm going to show the witness States 489 through 492 sequentially without skipping any numbers. Okay?
Yes, sir.
Now that you've had a chance to look at the photographs, can you tell us whether or not you recognize and can identify the scenes that are depicted in those photos?
I do.
Can you tell the jury that they fairly and accurately show the scenes as you saw them while you were there at the condominium on April 14th?
They do.
I would tender, Your Honor, State's Exhibits 489 through 492 sequentially without skipping any numbers, 413, 414, 416, 300, and 301.
Any objection from the defense?
I don't think so. Thank you.
Okay, they're admitted.
Let's start with states 410. And can you tell the jury, do you recognize states 410?
I do.
How do you recognize it?
That depicts the condominium as I saw it in April of 2017.
Okay. And what part of the condominium would this be?
I would call it a family and or living room area.
Okay. And behind the wall, behind the brown armoire that we see there in the top corner of the screen, right here, behind this wall, what is located?
I believe that's the bedroom.
Okay. This is states 409.
Yes,
You recognize that?
I do.
What is it?
It's the bedroom. It's the bedroom in 1501, I believe it was.
Okay. And can you tell the jury, in looking for those documents, did you also go into the closets located in the bedroom?
I did. I went into the closets. I looked up under the bed. I looked all over.
Okay. This is State's Exhibit number 413. Can you tell the jury what we are looking at in State's 413?
That was one of the drawers in the closet where we found some items in there.
Okay. State's Exhibit 414. What are we looking at in State's 414?
It's a bag that was inside the drawer.
And what color is the bag?
On this screen, it looks to be blue.
And can you tell the jury what was located in this blue bag?
There were some articles from a crematorium that were inside. It was a box.
And can you tell the jurors what was contained in the box?
According to one of the witnesses that was there, she said,
Don't tell us what
Okay.
the witness told you.
Okay.
Just describe what you saw.
Inside the box were little small vials, or vials rather.
Stage 301. Can you tell the jury what we see in stage 301?
Those are containers or canisters.
Okay. Now, this blue container that contained these small vials, do you know them as urns?
Yes.
Okay. This box, is that the same as this white object in this blue bag?
Yes, it is.
Let me let you look at this a little closer. You understand my question?
Yes, I do.
Okay. You want to change the last answer?
Yes, I do. The white box was the box that contained the blue box.
Take a look at stage 416. Did you actually see that?
Yes, I did.
And what is that?
It is a box that contained the item that we see in 301.
Okay. And how would you describe what we see in that photograph?
In 416,
Excuse me, can we approach side over very quickly, please?
Bet. Okay. And this is State's Exhibit 416.
okay.
Now, let me show you another photograph. This is State's 489. And do you recognize that?
I do.
And in what part of the condominium would this picture be taken?
It's in the bedroom.
And you saw those items there laying on the master bed?
Yes, I did.
Okay. And this is 490. appear to be letters or words that have a line stripping through them. Can you read those?
Yes, I can.
And what does the first one say?
On the bottom there, it looks like a cursive D, cursive R, cursive A, cursive I, cursive N, and then followed by DRS.
And D-R-A-I-N spells what word?
Drain.
Can you make out any of those letters or numbers?
The first line item appears to be 3,000. Second line item appears to be 12,000. Third line item, 170,000. Fourth line item, where it says cash, 130,000. I think I have 2020, but it appears to be 615,000.
And can you read the caption above those figures?
It's a little blurry on the screen.
Okay.
Assets. I can't make out the second word to DRS. Stock and deliverable to McIver. It's blurry on the screen.
I understand. It states 491.
Can I object to the strike?
So you can object, you're moving to strike. What I'll tell you all, ladies and gentlemen, is what was the exhibit that this was read?
490.
490. You've heard this phrase before, but it speaks for itself. You all will have 490, and you can read what those words say. You can read what those words say. I appreciate Investigator Salter's effort to try to read that, which was blurry, but it struck me as more guesswork than certainty, and so you should disregard his effort to read it and credit your own sense of what it says if and when you choose to look at 490. Anything else, Mr. Barber?
In either one objection.
Okay. Help me with that. Okay, but
Why is that not what it says? It's an out-of-court statement. It's an out-of-court assertion. Allegedly, that's what the purpose of the introduction of the evidence is, so why can't? So I think it is 801, it falls directly within 801, and it is, the content is objectionable.
so I've told the jurors to disregard what was read. If you, in the end, conclude that 490 ought not to go back to the jury, then it may not. We'll have the discussion of what goes back to the jury later. But I'm not sure what, other than saying take it down, which is already happened, you want me to do now.
Actually, what I want you to do is prohibit any other consideration of those items, because I believe that they are hearsay. I didn't object to the photographs, I object to the content.
Right. So I told the jurors to disregard what this witness said was in the picture. And I think that addresses it. At first I thought you were raising the objection because he was guessing, but there were other things maybe he didn't guess so much for, hence 801, and I think that's an appropriate basis as well.
Thank you.
All right. Back to you, Mr. Rucker.
Yes. Does the Fulton County District Attorney's Office maintain an evidence room?
Yes, several.
What is your responsibility with respect to the evidence rooms within the office?
My responsibility is to ensure that when evidence is transported to our office, that it is locked and secured, so that we maintain the chain of custody.
Okay. And can you tell the jury, was evidence for this case kept in one or more of those evidence rooms?
Yes.
And specifically, were any guns kept and secured in the evidence room?
Yes.
And can you tell the jury, did you receive guns for safekeeping in this case?
Yes.
When did you receive them?
I received guns back in January 11th. 2018 from the Putnam County Sheriff, and also from a law firm that was representing Mr. McIver.
Did you document the items that you received from the Putnam County Sheriff, which, by the way, do you know his name?
Sheriff Stills.
Is that S-I-L-L-S?
Yes, sir.
Did you document the guns that you received from Sheriff Seals as well as the law firm?
I did.
417. Let me have you take a look at both of these exhibits. And can you recognize and identify them?
I do.
And what is the first exhibit? First, call out the number, and then...
Exhibit 417 is a detailed statement of weapons that were transferred to my custody and control on January 11th, 2018 at 12:10 p.m.
Okay. And what is the second exhibit?
The second exhibit is a State's Exhibit 493. These were transferred to my custody and control on the same date from the law office, totaling 4 weapons.
Okay. Who was the person you received the 4 weapons from the law firm? What is the person's name?
Richard Hyde.
Do you know Richard Hyde? Have you seen him?
I think I would.
Okay, I'm just messing with you. And can you tell the jury, did you specifically document the types, the make and model, and caliber of the guns you received in both instances?
I did.
Did you tell us what date did you receive the guns from the law firm?
On January 11th.
Okay. And since that time, have they been maintained within the DA's office, secured under your care, custody, and control?
They have.
For purposes of the record, Your Honor, I would tender states 417. Is that right, Investigator Salter?
Yes, 417.
And what's the second exhibit?
493.
And 493.
493 is the list of weapons obtained from Mr. Hyde.
Correct.
417 from Sheriff Sills.
That's correct.
Okay. Similar documents, different sources.
That's correct.
And you'd like to make them part of the record?
I would.
Mr. Harvey, any objection to having 417 and 493 made part of the record? It's not a trick question.
I know that it may be a trick answer.
It usually is.
Yeah, I know. With me.
842.
Yeah. Go down and hook left, hit you on. Can we, I don't have one, that's right. Can we come sidebar again?
Okay. But I won't do that at all if you tell me you just want him out of the courtroom once Mr. Rucker is done.
My inclination at this point, my inclination at that point would be to get them cleared out.
Would you like me, though, to turn to you when Mr. Rucker's done to see if you have any questions about them, or why don't we do this so you, as if you're going to object, rise and say, Judge, actually, I'd like to ask a few questions now. I will grant that request. Okay, there'll need to be a few, the questions you have in connection with the firearms, if any, while they're still in the room.
That's fine.
The second thing I want to make clear, and I see at least one investigator here, as soon as Mr. Rucker makes it known that he's done asking questions about the firearms, I want that whole flotilla of investigators who are here quietly moving them out. Don't package them up while they're in here. You set up an assembly line so that they're out of the courtroom. Do all the packaging you want out of the courtroom. But quietly and quickly get them all out of here without dropping them, please. Anything else, Mr. Harvey, you want to discuss? We're going to talk more about these in terms of the witnesses tying it up when the jurors are gone for the day. You, of course, have preserved all your objections in connection with this, and you seem to have preserved some video footage of the display of the weapons. Anything else before we bring the jury in?
Well, just, and again, just let me preserve and reiterate again my objections with regard to the 403 prejudicial value. None of these long weapons have anything to do with the offense. They've got nothing to do with the offense at all. Its prejudicial value far outweighs any probative value. The physicality, now that you see them, is not translated that well in the pictures I gave you, but I think that with high quality, either video or pictures, it is adequately shown without this physical display of these firearms. So it's just
Preserved. I continue to find that in light of what has been represented by both sides in terms of handling guns and how the firearm went off, it is particularly salient in this case what Mr. McIver knows about guns and does with guns and how he handles them and his proficiency or lack thereof. So I think it's particularly relevant. I don't doubt that there are ways in which this display is prejudicial, but I make the specific finding that the prejudicial effect of this display of firearms that I believe the state will show were firearms of Mr. McIver's were at his ranch, in his condo, etc. The prejudicial value isn't so unfair such that that prejudicial effect substantially outweighs the probative value. Mr. Rucker, you ready? Yes. All right, let's bring the jurors in, please. And if you want to be particularly directive with your questions, I'm going to give you some leeway there to have this move a little faster. This is a little piece. Yes. All right, thank you, Deputy. Someone's phone needs to be turned off back there. Ladies and gentlemen, when we took a break, Mr. Rucker had begun asking Investigator Salters a little bit about some firearms that were obtained. We used the break to get some of those things in here. Mr. Rucker is going to ask Investigator Salters the questions he wants in connection with this. We'll see how that flows, if there are questions from the defense on that, and then these will get out of the courtroom, and we will keep moving on.
Investigator Salters, can you tell the jurors, based on the signed documents you have, how many guns did you receive from Sheriff Howard Seals from Putnam County?
The weapons from Putnam County included 43 weapons. 43 weapons.
And let me have you take a real close look at that document and look at the second page of that document. Do those last three items, are they weapons?
I'm sorry, they are not. So it's actually going to be 40 weapons.
40 weapons recovered or received from Sheriff Howard Seals, Putnam County.
That's correct.
Okay. And can you tell the jurors how many weapons did you receive from the law firm and Mr. Hyde?
There's going to be 4 weapons received from the law firm.
Okay. And can you tell the jurors, just for everybody's comfort, have all of these weapons that we see displayed in the courtroom, have they been made safe for transport and movement?
They have.
How was this done?
This was done by ensuring that the chambers on all weapons were clear, making sure that there was no ammunition in any chamber. There were also gun locks put in between the chamber and the magazine well. Or if the weapon could not have a gun lock put in between it, we put what's called zip ties in between it so that no chamber could be what we call loaded.
Okay. And there's no ammunition with these weapons, correct?
No ammunition.
And with respect to the weapons that you received, either from Sheriff Seals or Mr. Hyde, can you tell the jury were there any .38 caliber revolvers that you collected?
Yes.
And how many?
It was approximately 1, 2, 3, 4, 5.
Okay. And I'm going to put on the screen State's Exhibit number 369 and ask if you can read what that says.
Airweight, Smith & Wesson.
Smith & Wesson Airweight. Can you take a look at the revolvers you have in front of you, and can you tell the jury make and model?
This is a Smith & Wesson Airweight, model 38.
Sorry again, but it's not an objection, it's just a matter for the record. When you hold up something and say this,
I'm sorry.
without anything to identify it, we don't know.
You don't need to stand, that wasn't the concern, but for record purposes.
Yeah.
Those aren't labeled or anything, maybe you want to call them.
Court's exhibits or these.
I can read the serial number.
Serial number would be great.
Okay. Yeah, okay, identifying mark, yeah. For each weapon, before you identify, would you read the serial number to the record?
So the first one.
The first one would be serial number B Bravo E Echo A Alpha 2723. Again, that is BEA 2723. It is going to be an Airweight 38 Special.
Okay, go to the second one.
Second weapon is a Smith & Wesson Model 38. Serial number is going to be D Delta B Bravo 2243. Again, that is DBB 2243. Third weapon will be identified by serial number D Delta C Charlie.
Before we get started on the third weapon, what is the make and model of the second weapon?
Make and model of the second weapon is a Smith & Wesson. I'm sorry, yes, Smith & Wesson.
Is that an Airweight?
Yes, it is.
So let's start with make and model with each one you pick up. So number 3.
Number 3 is going to be a Smith & Wesson Airweight 38. Serial number D Delta C Charlie H Hotel 5612. Again, Delta Charlie Hotel 5612.
Is that a different make and model?
This is a different make and model.
This is number 4.
Yes, it is. It's going to be a Luger. Serial number is going to be actually a 22 caliber. Serial number 548-80302. Again, that's 548-80302. The last weapon is going to be a Smith & Wesson Airweight Model 38. Serial number is going to be C Charlie Y Yankee R Romeo 8460. Charlie Yankee Romeo 8460.
Okay. And with respect to all of those revolvers, can you tell the jury, does the hammer appear to be similar to what we see on the screen of Stage 369?
It is.
All of those revolvers have the hammer part right here.
Are you going to ask it? Just ask it.
Well, hold on. How is that a different question than what you just as opposed to emphasizing at the end of your examination? That's not, okay.
But to clarify, 3 are exactly similar to the one in the photo.
Okay.
Whereas 2 of them are not.
Okay. All right. I believe that concludes my demonstration, Your Honor.
Okay.
And so,
All right. Investigators, if you could start moving those. If you don't mind staying put, you can continue to ask questions. If we can get a flow here, we'll see how that works. It may just be another quick break where the jurors don't go anywhere.
Obey.
Mr. Rucker, you want the handguns to go as well? Yes, sir. Okay.
Investigator's office to assist with that.
Thank you. All right, Mr. Rucker. Yes.
Investigative officers, of your own independent investigation, do you know how many of the weapons that you received from Sheriff Seals or from the investigator, Mr. Hyde, belong to the defendant, and how many belong to Diane McIver?
I do not know.
And can you tell the jury, as far as your connection to the investigation or the presentation of evidence in this case, did you do anything else?
No, just obtained evidence.
Okay. All right. Thank you. That's all my questions.
Mr. Harvey, questions for investigators officers?
Good afternoon, sir.
You good?
Yes, sir.
All right, good. I understand that the weapons that we just saw displayed were seized by you, were gathered by you. Is that a
Yes, gathered.
terminology? It was gathered by you in April of 2017 from the sheriff of Putnam County, correct?
No, it was January of 2018.
Sorry, January of 2018 is when you gathered them, at least the long guns that we saw on the table, from the sheriff of Putnam County, correct?
Yes, sir.
The sheriff of Putnam County had those in his possession at the time that you picked those up, correct?
Yes, sir.
At the time that you picked those weapons, strike them. When one buys a weapon, for example, at a sporting goods store or a firearms shop, there are certain hoops that one has to jump through in order to purchase weapons, correct?
Yes, sir.
And one of the things that has to be done in order to purchase a weapon from a firearms dealer is that they have to fill out an ATF form, correct?
To my knowledge, yes, sir.
Okay. Have you ever bought a gun?
I have.
All right. And did you buy it from a dealer?
I sure did.
And did you have to fill out a form and answer questions?
I had to fill out a form and answer questions. However, with law enforcement, I don't think I had to go through the whole gamut, so I'm not that familiar with what a regular civilian would do.
But you know what civilians have to do.
Yes, sir.
If you walk into a gun shop as a civilian, as a 74-year-old guy, you walk in and you say hi to the owner, and I'm looking at this and I'm looking at that. And if you want to purchase something, you got to fill out a form.
Yes, sir.
The form is filled out under penalty of perjury. You can't lie on those forms, right?
You're not supposed to.
Well, you're not supposed to. You can. You can lie on the stand, but you're not supposed to, right?
Right.
Okay. That was no.
I understand.
Yeah. Okay. You fill out the form. You sign the form, and then the federal firearms licensee or the gun shop owner is supposed to do a background check, right?
Yes, sir.
And then if everything is satisfactory, you are allowed to purchase a gun, correct?
Yes, sir.
And there is a record, a record at the store where you purchased it, correct?
Yes, sir. To my knowledge.
Okay, to your knowledge, well.
I've never worked for ATF.
You're an investigator.
Yes.
Right? You investigate, you know what I'm talking about. You fill out a form, you go through a background check, and if you pass the background check, you're allowed to purchase the weapon.
Yes, sir.
Right? And the government's got a record of it, and the store's got a record of it. In simple language, right?
Yes, sir.
Okay, so we would be able to know which firearms were purchased at a store by Mr. McIver, correct?
We're supposed to, yes, sir.
Generally speaking, we'd also be able to know whether or not those firearms were purchased by someone else at another store or at another time, correct? You do an ATF trace, right?
It depends whether you gift a gun to someone or not, to my knowledge.
Sure. I'm talking about the
Yes, sir.
ones
Purchased.
that a store bought.
Yes, sir.
Because you can get a gun in a number of fashions.
Right.
You can get a gun as a gift.
Right.
You can get a gun at a gun show, and you pull it, they're now trying to close, right?
Yes, sir.
Okay. You can get a gun as a gift, correct?
Yes, sir.
You can hold a weapon that is somebody else's weapon for them, correct?
Okay.
You
can, yes, sir.
Okay, sure. Were you asked by anybody, asked or tasked by anybody to do any, you read us some serial numbers, to do any or to make any requests with regard to the serial numbers on any of the long guns?
No, I did not do anything as far as tracing the weapons.
Or any of the revolvers, the air weights, or the other weapon?
No, sir, I was tasked with housing it.
All right. So what you can tell us with regard to the guns, no, you strike them. Again, to your knowledge, is there any limit on the number of guns and I'm using guns, firearms, that any single person can own?
Not to my knowledge, no, sir.
Is there any limit on the number of sporting weapons like a shotgun that one can own?
No, sir.
There are no limits on the number of long guns that a person can own, correct?
Correct.
And there are no limits on handguns, whether it be a revolver or a semi-automatic, correct?
No limits, correct.
Okay. There are, as you know, places that handguns can be stored. Let me give you an example. It can be stored in a safe, a gun safe, correct?
Yes.
Stores, including firearms dealers, sell safes in order to store firearms, correct?
Correct.
You've seen either big ones, correct?
Correct.
Or small ones. I mean, shorter ones.
Correct.
You got to say yeah. You got to say
Correct.
yes to the court reporter. In other words, you could buy firearm safes so that you can store firearms in a safe, either a big safe, a small safe, or a bunch of guns, or just a couple of guns, right?
Yes.
People often also, in your investigatory experience, keep guns close, some short guns, some people even keep long guns, close to their physical presence for protection purposes, right?
Yes.
Okay. They keep them in their cars, right?
Yes.
They keep them in their houses, correct?
Yes.
They keep them in their, and this is based upon your experience, in their, what do you call those things next to the bed? Drawers? Nightstands. in their nightstand for easy access, correct?
Correct.
Sometimes they got them propped up by the front door, so if something happens and somebody knocks on the door, comes in the door, they can grab it right by the front door or something, right?
Correct.
Okay. There are a virtually unlimited variety of places that a handgun can be kept, or a long gun, right?
Right.
Unlimited variety of handguns or long guns that one is allowed legally to own, correct?
Correct.
And there are an unlimited number of places one can keep those guns for one's self-protection, correct?
Correct.
A revolver, to your knowledge, if you know, is a classic self-protection weapon. A .38 air weight is a classic weapon that one keeps for their own self-protection.
I don't know about, to my knowledge, to necessarily agree with that. I know it's a classic concealable weapon.
Okay. And one of the things that you do with a concealable weapon is carry it for your self-protection. It's light.
Certainly.
It can go into a pocketbook, for example, correct?
Correct.
It can go into a console, for example, correct?
Correct.
It can go into a glove box, for example.
Correct.
It can go into a number of places that make its access readily available to protect oneself, correct?
Correct.
Okay. Also, I think what you seized, or you retrieved, I'm sorry, from Sheriff Sills were some cartridges and some magazines, both pistol magazines and rifle magazines, correct?
Correct.
And 40 caliber, some 40 caliber cartridges, that's 25 of those, correct?
Correct.
The weapons that you identified for us, the handguns, those were .38 specials, right?
Yes, one of them was a .22 to my recollection.
Right.
Yes.
Not all of them. 4 out of 5, if I recall, right?
Yes, sir.
38s, right?
Yes, sir.
And I guess we'll talk more about that tomorrow with the crime lab folks. That fires .38 caliber cartridge, not cartridge cases, cartridges. Cartridges. Yes. Correct? 38?
Yeah, well, but there's a difference between you getting into revolvers versus handguns. I'm kind of newer, so when I came through, we didn't do revolvers, so I know some weapons are interchangeable with rounds.
Do you carry them?
Yes, I do.
What do you carry?
I carry a Glock. I carry a Glock.
9mm?
40 caliber.
Okay, 40. And do you carry that concealed?
Most certainly.
Okay. And you have a license for that, correct?
I have a badge for it. I don't need a license.
And I feel
I'm exempt.
I'm not. But oftentimes, those who carry concealed or want to carry concealed get a permit to do that, correct?
Yes, depending on your state. Georgia's an open carry state.
Yeah.
Yes, sir.
But you can also
Yes, sir.
get a permit.
Yes, sir. You can get a permit.
And you can get that from a court.
Yes, sir.
You do get that from a court, correct?
Yes, sir.
And that court also does a background check, correct?
Certainly.
Before they issue you that license?
Yes, sir.
Okay. Enough questions about guns, right? You also participated in a search of the condominium.
Yes,
right?
sir.
And am I correct in saying that happened in April of
Yes, sir.
2017?
Yes, sir.
Okay. And in April of 2017, you were one of the people that were searching that condominium, correct?
Yes, sir.
And you know, when you search, you want to be as thorough as possible, correct?
Yes, sir.
You want to get into all the nooks and crannies and other places that people use as their, I'm going to use this word, hidey holes. You ever hear that?
Yes, sir.
Okay. And sometimes when you're searching, an investigator like yourself, you pull down tiles from the ceiling, you look in the toilet tanks, you cut up the mattresses or look under the mattresses. But that's sometimes.
Yes.
Sometimes searches are done that way.
Yes, sir.
I guess my point is you want to be as thorough as possible, correct?
Yes, sir.
You want to make sure that you don't miss something that may or may not be hidden from plain view, correct?
Yes, sir.
That may be relevant to what you're searching for.
Yes, sir.
And in your search of the condominium, you were thorough, right?
Yes, sir.
And you searched every place you could think of.
I did, yes, sir.
Or that was obvious or visual or visible or not even obvious and visible, correct?
Yes, sir.
Okay, there was no will, right?
I did not find it.
Thank you.
All right. Anything on that note?
Why don't we let it end right there? You no questions from the state?
Yes, thank you.
Any questions from the jurors for Investigator Salters? Nope. All right. Thank you, sir. Before you go. It's about that time unless you've got...
I do. I have like a couple of seconds worth of evidence, and I'd like to publish the second stipulation.
Okay.
One that we refer to as the thing.
All right.
And that's the only thing left is
So ladies and gentlemen, we are going to get you out of here before 5 o'clock. You will recall that earlier this afternoon, and I'm looking for the language here to make sure I adhere to it, you saw a brief clip. You're going to see a different clip in just a moment. There was a different time. This would have been the day before, April 28th of last year was the clip you saw, 5 seconds up, however long it was. The day before, April 27th, a different reporter approached Mr. McIver without having let Mr. McIver know in advance that he'd be showing up, asked to speak with him. Mr. McIver agreed to speak with him. This was not a law enforcement interview. It wasn't an interview with lawyers present or anything like that. And there is a segment of that interview that, after discussions with both sides, I have deemed is admissible and thus publishable to you all. 485 was what we called the digs segment. This is the mini segment. Does it have an exhibit number so it can be made part of the record? 486. 486 is, okay, that didn't go in, so you're going to repurpose 486.
Yeah, we are.
Okay, and you promised me tomorrow morning I will have a revised exhibit list.
Promise.
Pinky promise?
Pinky promise.
So 485 was admitted, 486 is admitted. Is it queued up? No, you won't. Yeah. All right. Are we ready?
Yes.
We will publish, you will publish 486.
Got everybody shooting her.
Guns are not my thing. There were some theories that this had been done because of my need for her money and so on. It's just not the case. As it turns out, she was very, very successful in her own right, coming the way she did, but I was more.
That's all of 486? Okay. Ladies and gentlemen, we are done for Wednesday. Tomorrow's Thursday. That's how the weeks work. I have a meeting that has been rescheduled a bunch of times because this trial has kept going, and I have to go to it tomorrow morning because I host it. It is just 5 floors up. So I'll be here, but it's going to be closer to 9:30. You're welcome to get here at the time you normally do and have the freshmen get together, as long as you're not talking about the case. But know that we won't be asking you to come out here till around 9:30. So you won't be late if you come in at 9:15, because we won't get started before 9:15. And there'll be no fussing at anyone if they come in at 9:15. We'll try to get started as close to 9:30 as possible. We've got a particular time we need to break for lunch, and then we'll go, is tomorrow, so the lawyers can plan a 5 or a 6? It's a 6, okay. You guys will work through that, but I'm aiming for 6, especially since we're not starting until 9:30. But you talk amongst yourselves, you can let us know in the morning, but we'll make sure the state has enough folks to get us through 6, and if we end a little early, they will have had enough folks to get us through 6 o'clock. Thank you for your time. Enjoy your evening. We'll see you around 9:30 tomorrow morning. All right, you all can be seated. A few things to talk about. We've talked about exhibit list, and I have a pinky promise there'll be one that goes to the numbers it needs to tomorrow. I think it's important to get on the record that as soon as Mr. Rucker indicated he was done asking Investigator Salters about the firearms that had been displayed to the jurors, I checked with Mr. Harvey. He indicated that he didn't have any questions at that point. I had given him the opportunity so that the firearms would not have to be brought back into the courtroom. If there was anything specific he wanted to ask Investigator Salters while the firearms were still in the courtroom, that he could do so even though the direct exam was not completed. Mr. Harvey indicated he was not interested in doing that. And then the team of investigators with the district attorney's office promptly and efficiently got the guns out of here. That won't be clear on the record, but it should be made clear on the record. Mr. Rucker has represented to the defense and to me that he will get Sheriff Sills into court at some point during the state's presentation to attempt to complete the chain of custody for those firearms that came from the ranch property as opposed to from the condominium. That was a request made by Mr. Harvey. It was an appropriate request. So you're going to get the sheriff in here in the way that makes sense for your presentation, but you have represented, and that's why I have allowed in or to be displayed those firearms. You, at my request, Mr. Rucker, went straight into the discussion of the firearms. You had had 2 exhibits, 493 and another one that were the lists that you wanted admitted into the record to really document what was there. And I'll allow those into the record. They're admitted provisionally now because, well, one of them is admitted, the one that documents what was obtained from Mr. Hyde. Mr. Harvey had no objection to that, I believe. We'll get a chance to talk in a minute. The other one was the 40 firearms plus a few other items that I think got to 43. Which one was that? Is that 493 or is that the other exhibit?
Yes, 493, I think it's the first one.
493 is the one from Mr. Hyde.
Okay.
417.
417 is the other exhibit.
Yep.
Okay, those are both admitted, meaning they'll be made a part of the record. 493 is in, we don't need to do more with that. 417 is admitted, subject to being unadmitted if after, either you don't call Sheriff Sills or if after his testimony there continues to be a chain of custody concern that I find has merit. Then some other issues too, but 417 won't be admitted. Finally, we had a sidebar concerning some of the pictures of the mini urns in which Mr. Harvey raised a relevance objection and then segued neatly into a suppression question in light of what the search warrants for the Kingsborough condominiums were actually for. We moved away from the photos after that jury thus far. But I hadn't been thinking about it from a suppression perspective until that was brought up. So I don't know, Mr. Harvey, what more you want to get in the record on that. We pivoted away from it after that, but I want you to make the record that you'd like to make in connection with that.
Well, I think that in making that record, my understanding of the search warrant for the condominium was that it allowed for the seizure of documents, and I think financial documents. Clearly pictures of urns does not fall within the definition of documents or financial, particularly financial documents. That image was seized, and it was seized and presented. So it falls, it by definition, falls outside the scope of the search warrant, and therefore is inadmissible per se. So that would have been my objection. Now, I think that is still outstanding.
So what I'd ask you to do, and it may be something you can get for me now, you can have it in the morning, is case law that supports the notion that photographs to preserve the scene in case someone were to say, you took one of my urns, you broke this, the apartment, the condominium wasn't in this condition when I left it, and you guys showed up and did this or that, how photographs constitute a seizure as opposed to the recordation of a place where law enforcement was lawfully present by dint of the warrants. And I believe that opening the box to make sure there weren't financial documents was appropriate. And what was then reported, and you're calling it a seizure, was a photograph of what was in the box. I'm not disagreeing with you, I'm questioning whether that is problematic under the Fourth Amendment. I don't know the answer. You probably do. But if you don't, I would invite case law that says that taking a picture of it, as opposed to having the urns in court and displaying them because they physically seized them, took them from the apartment, and are using them as evidence. And they are of a species, but there's a difference. So that's where I am on that.
Just like a photograph was substituted for the firearms, right?
You're welcome.
But no, I've got nothing else to add, and I will try to provide you with any authority I can come up with.
Okay.
Thing for you to sign, one more document for you to sign.
What we discussed, sidebar.
Right.
Okay. I'll remember it, I'm sure, when I see the document.
Which doesn't necessarily have to be on the record.
Okay, I'll take a look at that. I got onto the record the things that I had on my list. Anything from the state before we go off the record for today?
No.
Okay, you'll have witnesses for tomorrow?
Yes, sir.
Okay. Anything from the defense other than what you've got in your hand, which I'll certainly look at in just a moment?
No, and I'll try to talk with Mr. Rucker about one minor concern that I have.
Okay, well, if it's minor, I hope we can work through it. On the media front, we still have two witnesses / documents outstanding. I don't know if it's Ms. Convery, has the state been working with Mr. Samuel or anyone from the defense on the AJC Schneider piece of it?
It's on my list for tonight. We were making sure we got the second part of the video okay.
Okay.
And I plan to look at it again tonight, confer with them, and see if we can make the same kind of progress we made today.
Okay.
If we get to an impasse, of course we'll.
Great. And then the way I have left the Ms. Hobbs' daily report things, it's really pretty highly contextual after Mr. Crane testifies. We'll be in a better position to work through that. All right. Thank you. So, 9:15, 9:20 tomorrow. I think being here. I'm getting rid of that.
Thank you, Ms. Ingram.